kitty, you got frosting all over your face. That salad, you goofball. Kitty doing a salad. That kitty does. Kitty's in your salad.
All right. Hey, Nick. Good to see you, guys. Gotta get a couple of tabs set up here. All right. Got that. Hey, guys. Everybody's starting to sign in. I gotta go get a soda.
Eating your salad.
That's okay. I'm done with it.
What could you do now? You did my salmon and my mouth with
That's
the
okay.
frosting in your salad.
You protect that. I gotta get back. I'm live on the air, so.
No.
And we're back. Let's see. I've got 8:55 on the phone, so the 5-minute buzzer at the court should be going off here pretty quick. Double check over at SCOTUS blog. Yep, they got the 5-minute buzzer. Waiting on a box count to see. So we have 18 opinions we're waiting on at this point. And if you count the Chevron case and the Facebook cases, there's 2 on each of those. So really, we've got 16 opinions. They have added next Wednesday as an opinions day. So we know we're not going to get 16 opinions today. So we shall see. I'll double check something. Somebody yesterday was complaining about me coughing up a lung, so I'm trying to use my mute a little bit more for that. No, that's Diet Coke. I don't drink coffee, generally speaking. Although, if I do, Gun Barrel Coffee is good stuff. The guys, Sal and the guys over there, have been supporters. Appreciate them. They were really great guys. They sent a whole big case of stuff to me for the ICU nurses when Amy spent over a month in ICU down at Russian downtown, and kept the nurses going since I was there 24/7 for the most part. But let's see if I can do a split screen for me here. So yeah, there we go. I got part of it now. Let's see. 3 boxes today. Ooh, 3 boxes. So depending on how long the opinions are, we're probably looking at 4 opinions today, maybe 5, depending on how long this stuff goes. So is today that? So let me run through my Rahimi predictions real quick. I'm hoping Alito writes it. If the chief writes it, it will be fairly narrow and not great for us. I'm hoping Alito writes it because I think Alito will get more in the weeds on things and do us a better job. I think that they will overturn the Fifth Circuit and find that 922G is not facially unconstitutional. That, as applied to Mr. Rahimi, he can be barred the ownership of firearms. That dangerous people can be barred the possession of firearms. I'm I think they will do a little bit more in getting to that opinion. They will flush out some of the text, tradition, and history as to how that test is to be applied. And I would be really thrilled. The question then is, do they say anything about ex parte orders? Do they say anything that would be red flag laws? The ex parte is the biggest thing. If we can get something on the ex parte, if you go down the due process road where you have to be afforded a hearing, or you can have counsel, or you can ask questions of hostile witnesses, or present your own rebuttal witnesses, the full throttle protections of the Sixth Amendment. If we can get that, then I think we are in a very good way. Let's see. Let's see what we have. Let me mute this. Sorry about that. Just trying to clear my throat. I've still got this tickle or whatever. Let me see if I change this over. Can I still? I'm playing with my spare window so I can see things. Yeah, that works. That works. And what do we got here at the court? Pings page. That's there. I'm playing with my tabs over here so I'm bouncing back and forth between a couple of places to watch to see what comes out and when. So, and then I go over here to Twitter real quick. Let's get back over here, tab to here. First case from Justice Jackson. Let's see. Texas v. New Mexico. It's a water case. Okay, so they're starting from the bottom with all right. So as we know, the court releases opinions with the most junior jurist first. Thomas is the most senior, but the chief because of his title. So Jackson. So we can get an opinion from anybody else. I mean, if it was all going to be the chief judge all the time, if the chief judge releases an opinion, nobody but the chief judge is going to release an opinion for the day. So, hey, Shave, nice to see you again. So here we go. Let's see. It's a 5-4 decision. Gorsuch dissents, joined by Thomas, Alito, and Barrett. So looks like you're missing one. 1, 2, 3. Oh no. So Kavanaugh and the chief went with the liberals on this one. So the U.S. prevails. The state's objections about water rights doesn't carry the day. No wonder Gorsuch being a Western guy, he's all into that kind of stuff, the Native American stuff, everything else. So Amy's at the breakfast table, and I just commented, and I hear her in the background going, "Yay!" Sweetheart, the guys on the broadcast say hi. She says hi back. Yeah. Yeah, that's one of the gun guys texting me. Everybody's all doing SCOTUS. They're all waiting for the pronouncement. So we'll see if Jackson reads a long opinion from the bench and slows things down or not. One of the guys texting. So we've got 4 boxes today. So 4 to 5 opinions is the box count as I saw. Oh, sorry, 3 boxes today.
Four.
3 boxes. So 4 to 5 opinions is the guesswork on this. Let's see. Let me see how long Jackson's opinion is. Jackson's opinion is 48 pages. So I don't know how many copies they typically put in each box. Let's see. If you can hear Amy in the background from the kitchen. Yep. Yeah, it's Aloha Friday. A bunch of my operator friends do this when they go to work. And it was the first shirt I grabbed that, like, out of the closet. Like, okay. Hey, Pete, how you doing? Brian, no, I do not believe that the liberals have split on any cases. Yeah, Joe, I wish it was 4, but I misread that. It's 4 to 5 opinions, 3 boxes. Department, next is Department of State versus Munoz by Justice Barrett. This is interesting. So, all right, Justice Barrett. So let me get back over. So she's one above Jackson. So Jackson, Barrett. So you got Kavanaugh, Gorsuch, Kagan, Sotomayor, Alito, and Thomas still left here. But they're releasing them a little quicker. It must be that Jackson didn't read her thing from the bench. So this is about a non-citizen spouse being able to get a visa. The court holds that a citizen does not have a fundamental liberty interest in her non-citizen spouse being admitted to the country. That's going to be interesting considering what Biden just did. That's going to be real interesting. Because Biden just said all those not spouses and whatever. Wonder if they were thinking they were going to lose this case and wanted to do something in front of it. So now the court looks like a bunch of big old meanies. They didn't say what the split is. 6-3, there it is. Sotomayor dissents, joined by Kagan and Jackson. So the conservatives seem to be reining in some immigration policy. Yeah, save. If I didn't have so much other stuff to do, it's Amy's birthday Sunday. She'll turn 66, and we're having a few friends over. So I've got a lot of cleaning up to do and catching up, and we have a little bit of shopping to do. So otherwise, yeah, I could be very easily talked into starting a margarita right about now or a Bloody Mary. Mm. History and tradition. All right. So remember how the liberals went absolutely batshit stupid about history and tradition in the New York case? Here, this is a synopsis from SCOTUS blog. Probably Amy Howe's writing this. Barrett explains that Munoz's argument is built, quote, on the premise that the right to bring her non-citizen spouse to the United States is an unenumerated constitutional right. To establish this premise, she must show that the asserted right is deeply rooted in this nation's history and tradition. End quote. But Barrett writes she cannot. In fact, Congress's longstanding regulation of spousal immigration, including through bars on admissibility, cuts the other way. So history and tradition. Remember that they blew up about history and tradition in um, in New York, in what everybody else calls the Bruin case. I hate calling it by the loser's name. But in that, here you go, the court history and tradition, and they use this exact phrase in a decision yesterday. So you can see that there is a pattern here that the justices are following. I think we will see history and tradition allows the disarming of dangerous individuals, whether or not they define dangerousness. And if they take the Solicitor General's definition of felony level conduct, that's good for us. Sotomayor cries the majority today chooses a broad holding on marriage over a narrow one on procedure. So, all right, we're waiting on number 3. Hopefully, we get 2 more. Now, when they issue an what's called an R number, there's a R that goes with the case number. Um, that indicates it's the last opinion being released for the day. So, when we have an R number, we know we're done. That's it. So, we'll see how and when that comes around. Uh, Next case is Erlinger versus United States by Gorsuch. Okay, we're working our way up the food chain as I drop this over to Twitter. So now we have above Kavanaugh's out for today. You've got Kagan, Sotomayor, Alito, Thomas, and Roberts. That's where we are at this point. It's 6-3 on this case. Kavanaugh dissenting, joined by Alito and in part by Jackson, who also has her own dissent. Question before the court is arising under armed career criminals. So, what's it say here on that? Held, the Fifth and Sixth Amendments require a unanimous jury to make the determination beyond a reasonable doubt that a defendant's past offenses were committed on separate occasions for the Armed Career Criminals Act purposes. This is interesting. I wonder how this stuff is going to tee up for the Trump stuff. The Fifth Amendment further promises that government may not deprive individuals of their liberty without due process of law. It safeguards for criminal defendants well-established common law procedures, including the ancient rule that government must prove to a jury every one of its charges beyond a reasonable doubt. Together, these amendments place the jury at the heart of our criminal justice system. On the power to punish is derived wholly from and remains always controlled by the jury and its verdict. That's very interesting. That's what else they throw in here? Anything else? Court appointing. That's an interesting case. So that's talk about hung juries and or jury nullifications. So that's three. So we're getting at least one more today. Getting at least one more. I text a couple guys. Let's see. Paul, thank you. Chris, thank you. Sapien, yeah, you just dropped me an email. And I can hook you up on the patches or stickers that I have. Let's see. Come on, guys. Gorsuch is still reading his opinion on the armed career criminal from the bench. There is no live audio for when they do this. I wish they would. But this, as long as he's reading, they won't release the next opinion. We have Smith v. Arizona by Kagan is the next opinion. And if there's no R number, that means we'll be getting 5 today. So Gorsuch, Kagan, that's in that order. So there's 4 opinions. So 18 opinions minus 2 because of the doubled up cases. That's 14. Looks like it's unanimous. So so it looks like we're going to get 5. Looks like they may be holding on to Rahimi, Chevron, Trump till next week. They've already added next Wednesday. If we get 5 today, 14, 13, yeah, they're going to need at least 2 days next week unless they just really drop a pile of opinions. They've added Wednesday. They could add Thursday and Friday. Or they could push it into the next week. There's some reporting out there that on the New York case from 2 years ago, they had a hard time cobbling together a majority until the chief and Kavanaugh got some modifications that Thomas wanted to go much farther. Let's see. So this case is about a confrontations clause within the Sixth Amendment on the right to confront witnesses. Well, there's a Sixth Amendment which guarantees a defendant the right to confront the witnesses against him, allows prosecutor to use expert testimony without evidence, Here, a report prepared by a different crime lab analyst who no longer worked at the lab and did not testify at trial that was not itself admitted into evidence. The grounds that the testifying expert was simply offering his own opinion that the defendant could have subpoenaed the original analyst. All right. The court rules today that when an expert conveys an absent analyst statements in support of the expert's opinion, and the statements provide that support only if true, and the statements come into evidence for their truth. So this is going to be, I would assume this is narrow about written reports, which I wonder how that's going to play with experts in our stuff. I wonder how the Sixth Amendment stuff will play into red flag stuff. That you lose your rights on the front side based on not being able to confront anybody or whatever. This is how, other cases, you need to look at them to see what they're going to do to what how it all dovetails and how we piggyback off of that. What else are we gonna get? This is going to be a technical decision, but it's going to be interesting. Imaginary, not on the semi-auto ban. I don't think so. I think part of it, if I can read the tea leaves, I think the chief likes to move incrementally. Go read the chief's concurring opinion in Dobbs to where he would not have struck down Roe, but he would have gone about halfway. I think it just measures the chief's it's the way he wants to operate with the court. Move it a little bit at a time. Don't make huge sweeping changes. But the trick there is Kavanaugh. Then is Kavanaugh becoming a bit of a squish? But Kavanaugh wrote a dissent that in the Heller 2 case that they couldn't ban AR-15s. No, can't do it. So it's around the peripheral on, and there's part of this report is that the Uvalde shooting may have had an impact on this, and then obviously that the guy stalking Kavanaugh's house there to attack him may have thrown. But if anything, wouldn't let Kavanaugh get a carry permit for whatever state he's in, Maryland, Virginia. Well, Virginia's not a bad state for carry permits, but Maryland is, and getting that. So let's see. We're waiting for at least one more opinion. And Sotomayor is the only bad judge on the list, but you got Alito, Thomas, and the chief. So depending on where we go, you would think that they would release maybe one bigger. Fifth and final decision of the day is Rahimi. Rahimi is out. Okay. Who is it? It's by the chief. Oh, the chief writes Rahimi. Let's see what's going to happen here. Okay, I'm waiting for the link to populate. Rahimi is out. Oh, be still my heart. Now let's see if I have if I have a good reason or a crazy reason to go drinking. Rahimi in the held. When an individual has been found by a court to pose credible threat to the physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment. Okay. Since the founding of the nation, laws have included regulations to stop individuals who threaten physical harm to others from misusing firearms. As applied to the facts here, 922G8 fits within this tradition. The right to keep and bear arms is among the fundamental rights necessary to our system of ordered liberty, McDonald v. Chicago. That right, however, is not unlimited. The reach of the Second Amendment is not limited only to those arms that were in existence at the time of the founding. Rather, it extends prima facie to all instruments that constitute bearable arms, even those that were not yet in existence. By that same logic, the Second Amendment permits more than just regulations identical to those existing in 1791. Okay, this gets into the analog stuff. Excuse me. Under our precedent, the appropriate analysis involves considering whether the challenged regulation is consistent with the principles that underpin the nation's regulatory tradition. I got to text somebody here real quick. Give me just a second, guys. So, under our precedent, the appropriate analysis involves considering whether the challenge regulation consistent with the principles that underpin. I'm blowing this up because my old eyes. The nation's regulatory tradition, Bruin, when the firearm regulation is challenged under the Second Amendment, the government must show that the restriction is consistent with the nation's historical tradition of firearm regulation. A court must ascertain whether the new law is relevant. A court must ascertain whether the new law is relevantly similar to laws that our tradition is understood to permit, applying faithfully the balance struck by the founding generation to modern circumstances. Why and how the regulation burdens the right are central to the inquiry. All right. As Bruin explained, a challenge regulation that does not precisely match its historical precursors still may be analogous enough to pass constitutional muster. Section 922G survives Rahimi's challenge. Rahimi's facial challenge to 922G requires him to establish no set of circumstances exist under which the act could be valid. All right, this goes back to Salerno. Here, Section 922G is constitutional as applied to the facts of Rahimi's own case. Rahimi has been found by a court to pose a credible threat to the physical safety of others, and the government offers ample evidence that the Second Amendment permits such individuals to be disarmed. The court reviewed the history of American gun laws extensively in Heller and Bruin. At common law, people were barred from misusing weapons to harm or menace others. Such conduct was often addressed through ordinary criminal laws and civil actions, such as prohibitions on fighting or private suits against individuals who threaten others. By the 1700s and 1800s, through two distinct legal regimes, had developed that specifically addressed firearm violence, the surety laws and the going armed laws. Surety laws were a form of preventative justice. Blackstone Commentaries on the Law of England, which authorized magistrates to require individuals suspected of future misbehavior to post a bond. If an individual failed to post a bond, he would be jailed. If the individual did not post a bond and then broke the peace, the bond would be forfeit. Surety laws could be invoked to prevent all forms of violence, including spousal abuse, and also targeted the misuse of firearms. These laws often offered the accused significant procedural protections. All right, that's important. The going armed laws, a particular subset of the ancient common law prohibition on a phrase or fighting in public, provided a mechanism for punishing those who had menaced others with firearms. Under these laws, individuals were prohibited from riding or going armed with dangerous or unusual weapons to terrify the good people of the land. Blackstone. Those who did so faced forfeiture of their arms and imprisonment. Prohibitions on going armed were incorporated into American jurisprudence through the common law. Together, the surety and going armed law confirm what common sense suggests. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. Section 922G is not identical to these founding era regimes, but it does not need to be. Like the surety and going armed laws, Section 922G applies to individuals found by the court threaten the physical safety of another. This prohibition is relevantly the burden in Section 922G imposes on the right to bear arms also fits within the nation's regulatory scheme, while the court does not suggest that the Second Amendment prohibits the enactment of laws banning the possession of guns by categories of person thought by a legislature who present a special danger or misuse. Let's see. 922G applies only once a court has found that the defendant represents a credible threat to the physical safety of another, which notably matches similar judicial determinations required in the surety and going armed laws. Moreover, like surety bonds of limited duration, only prohibits firearm possession so long as the defendant is subject to a restraining order. Finally, the penalty. Another relevant aspect of the burden also fits within regulatory tradition. Going armed laws provide for imprisonment, and it was permissible to respond. Hey, babe, we got a court case. The court decision. Amy's trying to wheel herself in here. The court decision in Heller and Bruin do not help Rahimi, while Section 922G bars individuals subject to restraining orders from possessing guns in the home. Heller never established a categorical rule. The Constitution prohibits regulations that forbid firearm possession in the home. Indeed, Heller stated that many such prohibitions, like those on the possession of firearms by felons and the mentally ill, are presumptively lawful. The court's conclusion in Bruin that the regulation, like the surety laws, are not proper historical analog for the broad gun licensing regime does not mean that they cannot be appropriate analog for a narrow one. Fifth Circuit erred in reading Bruin to require a historical twin rather than a historical analog. Finally, the court rejects the government's contention that Rahimi may be disarmed simply because he is not responsible. The court used this term in Heller and Bruin to describe the class of citizens who undoubtedly enjoy Second Amendment right. Those decisions, however, did not define the term and nothing about the status of a citizen who were not responsible. Roberts delivered the opinion of the court in which Alito, Sotomayor, Kagan, Gorsuch, Kavanaugh, Barrett, Jackson joined. Sotomayor filed a concurring opinion, which Kagan and Jackson joined. Gorsuch, Kavanaugh, Barrett, and Jackson filed another concurring opinion, and Thomas dissents. So now that is the holdings from the syllabus of the court. Let me flip over here to SCOTUS blog for a minute, guys. I'm going to go back.
Did you check your phone?
Yeah, I'm watching my phone, sweetheart. Oh, there. All right. So I'm going over to SCOTUS blog because they're doing a recap on some stuff. Let's see. Roberts explains, discussing the application by lower courts of the Supreme Court's decision in New York State Rifle and Pistol Association v. Bruin. Robert writes that some courts have misunderstood the methodology of our Second Amendment cases. These precedents were not meant to suggest a law trapped in amber. Otherwise, he explains the Second Amendment would only provide protections to muskets and sabers. All right, that's good. So we're gonna have to get into the entire opinion because there's going to be a lot of nuance here. So it there's 103 pages with all the concurrences and everything. So guys, let me start reading through this. It's by the chief. It's narrow in general. He throws down a few markers. They are clearly telling the lower courts they're getting some of this wrong. And I think it cuts both ways. I think they're telling the Fifth Circuit on this one, you got it wrong. Who said that? Keith, no, it clearly shows that there has to be some sort of court hearing. Let me get into the meat. Let's see. This is the background. I don't care about what Rahimi did. Why is Colt barking so much? My dog is outside barking up a storm. Huh? All right. Court. Okay. In light of Bruin, the panel withdrew the prior opinion. We granted cert. All right. Let's start here. When a restraining order contains a finding that an individual poses a credible threat to the physical safety of an intimate partner, that individual may, consistent with the Second Amendment, be banned from possessing arms, although orders in effect. Since the founding, our nation's firearm laws have included provisions preventing individuals who threaten. All right, that's not good for the ex parte stuff. That says that if the court makes a finding, that's good enough. That's not good. We've held that the Second Amendment among fundamental rights. Yes, this revolution. Let's see. I'm scrolling through trying to find the meat and potatoes. Like most rights, the Second Amendment is not unlimited. Yes, we hear that all the time. We recognize the right was never thought to sweep indiscriminately. Let's see. In Heller, our inquiry to the scope of the right with constitutional text, we explain that if a challenge regulation fit within the tradition, it is lawful under the Second Amendment. We also clarified that when the government regulates arms-bearing conduct, is when the government regulates other constitutional right, it bears the burden to justify its regulation. They are doubling down on New York here. These precedents were not meant to suggest a law trapped in amber. As we explained in Heller, for example, the reach of the Second Amendment is not limited to only to those arms that were in existence at the founding. Rather, it extends prima facie to all instruments that constitute bearable arms, even those that were not yet in existence. By that same logic, the Second Amendment permits more than just those regulations identical to those ones that could be found in 1791. Holding otherwise would be to mistakenly apply the protection of the right only to muskets and sabers. As we explained in Bruin, the appropriate analysis involves considering whether the challenge regulation is consistent with the principles that underpin our regulatory tradition. A court must ascertain whether the new law is relevantly similar to laws that our tradition is understood to permit, applying faithfully the balance struck by the founding generation to modern circumstances. Discerning and developing the law in a way is a commonplace task for any lawyer or judge. Why and how the regulation burdens the right are central to the inquiry. For example, if laws at the founding regulated firearm use to address particular problems, that will be a strong indicator that contemporary laws imposing similar restrictions for similar reasons fall within permissible category of regulations, even when a law regulates arms bearing for the permissible reason, even though it may not be compatible with the right if it does so to an extent beyond what was done at the founding. And when a challenge regulation does not precisely match its historical precursors, it still may be analogous enough to pass constitutional muster. The law must comport with the principles underlying the Second Amendment, but it need not be a dead ringer. Bearing these principles in mind, we conclude that Section 922G survives Rahimi's challenge. All right, this is an as applied to Rahimi. The facial challenge is out the window, and as applied to Rahimi, which I'm going to read to say that if this were applied to other individuals with a different fact pattern, it may not bar them from owning guns. And in their cases, they may get relief. This is the most difficult challenge to mount successfully because it requires a defendant to establish that no set of circumstances exist. Yeah, that's the facial side. That means that the government need only demonstrate that 922G is constitutional in some of its applications. Yeah, that's the whole facial thing. Basis for liability, bars individual possessing firearms if his restraining order includes a finding that he poses a credible threat. Separately, so there has to be a finding of a credible threat. They're just, in my open reading of that, It's just there has to be a credible threat of physical violence. Our analysis stops and starts with Section 922 G8C1 because the government offers ample evidence. Hold on just a second, guys. Sweetie, what are you going to do, babe? All right, let me go. Guys, hang on. I got to deal with my dog. I will be right back. Let me go deal with. Wait, here. I'll deal with it.
Grab the duck.
You know what it is?
A bird.
No. He got trapped in the pool area.
Oh.
Excuse me.
Them.
Sorry for that. The reason my dog was barking is somehow he got out, got trapped in the pool area. So here we go. We're back. Our analysis starts and stops with that. The court reviewed the history of American gun laws extensively in Heller and Bruin. The Glorious Revolution cut back on the power of the crown to disarm its subjects unilaterally. King James II had caused several good subjects, being Protestants, to be disarmed. And talks about disfavored group. The English law also had disarmed not only brigands and highwaymen, but also local political opponents and disfavored religious groups. But at the same time of the founding, however, the state constitution and Second Amendment had largely eliminated government authority to disarm political opponents. But regulations targeting individuals who physically threatened others persisted. Such conduct was often addressed through ordinary criminal laws and civil actions. The first were surety laws. Okay. This broadcast we're at 45 minutes. It's going long. So, I'm going to skip through a bunch of this, and then we'll probably cut this off at the 1 hour mark, and then I'm going to go back and cut another video. Importantly, for this case, the surety laws also target the misuse of firearms. In 1795, Massachusetts enacted a law authorizing justices. Let's see, these laws offered the accused significant procedural protection. All right, this is interesting. The laws often offered the accused significant procedural protections. Before the accused could be compelled to post a bond for going armed, a complaint had to be made to a judge or a justice of the peace, and any person had reasonable cause to fear that the accused would do him harm or breach of peace. The magistrate would take evidence, and if he determined the cause existed for the charge, summon the accused, who could respond to the allegations. Bonds could not be required for more than 6 months at a time, and an individual could obtain an exception if he needed his arms for self-defense or some other legitimate reason. Well, the surety laws provided a mechanism for preventing violence before it occurred. The second regime provided a mechanism for punishing those that menaced others. These were going armed laws. A particular subset of ancient common law prohibition on a phrase. Let's see. Don't go to class. All right, I'm trying to skim through and figure out what's really relevant and what's just background. Surety and taken together, the surety and going armed laws confirm what common sense suggests. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. 922 G8 is by no means identical to these founding era regimes, but it does not need to be. Its prohibition on the possession of firearms by those found by a court to present a threat to others fits neatly within the tradition. Like the surety and going on, Section 9 complies. The burden section imposed on the right to bear arms also fits within a regulatory tradition. While we do not suggest Second Amendment prohibits the enactment of laws banning the possession of guns by categories of persons, we note that Section applies only once a court has found that the defendant represents a credible threat to the physical safety of another. That matches the surety and going armed laws. Moreover, like surety bonds of limited duration, Section 922 restriction was temporary as applied to Rahimi and only prohibits firearms possession so long as the defendant is subject to a restraining order. In Rahimi's case, finally, the penalty, another relevant aspect. Yeah, not worried about the penalty. Um, Analysis of surety laws. While we also noted that surety laws apply different penalties than New York's special need regime, we did so only to emphasize how severely the state restricted the rights of its citizens. But as we have explained, our nation's tradition of firearm regulation distinguishes citizens who have been found to pose a credible threat to the physical safety of others. The conclusion that focused regulatory surety laws are not historical analog for a broad prohibitory scheme like New York does not mean they cannot be appropriate analog for a narrow one. Okay. In short, we have no trouble concluding that Section 922G survives Rahimi's facial challenge. Right? Our traditional farm regulations allow government to disarm individuals who present a credible threat to the physical safety of others. That phrase is being used throughout here. The dissent reaches a contrary conclusion, primarily on the ground that the historical analogs for 922G are not sufficiently similar to place that provision in our historical tradition. The dissent does, however, acknowledge is within the tradition when it comes to the why of the appropriate inquiry. The objection is to the how. Okay. For its part, the Fifth Circuit made two errors. Um, it's looking for a historical twin. Kyle applied to Rahimi, reject government's contention that Rahimi. All right, so here, this is interesting. Finally, in holding that 922G is constitutional as applied to Rahimi, we reject the government's contention that Rahimi may be disarmed simply because he is not responsible. Brief for the United States. Responsible is a vague term. It is unclear what such a rule would entail, nor does such a line derive from our case law. In Heller and Bruin, we use the term responsible to describe the class of ordinary citizens who undoubtedly enjoy a Second Amendment right. But those decisions did not define the term and said nothing about the status of citizens who were not responsible. The question was simply not presented. In Heller, McDonald, Bruin, this court did not undertake an exhaustive historical analysis of the full scope of the Second Amendment, nor do we do so today. Rather, we conclude only this: an individual may be found by the court to pose a credible threat by the physical safety of another, may be temporarily disarmed consistent with the Second Amendment. The judgment of the Court of Appeals for the Fifth Circuit is reversed. The case is remanded. A narrow decision. They shed some light on history and tradition. Um, they talked about they I think shot down this responsible citizens argument that has been hanging out there that the government and the anti-gunners keep putting out. They talk about there has to be a credible threat. So I think that's going to have an impact on red flag laws. And I'll have to go back and read how our red flag law is done to see if they use that term credible threat or not, or whatever. I'll have to go back and look at. Did they say dangerous or unusual? Let me look. Let's see. All right. They use dangerous or unusual in the syllabus. That's a good catch. That's a good catch. That's interesting. But later on, they quote dangerous and unusual weapons. Some jurisdictions ban the carrying of dangerous and unusual weapons. So in the syllabus, let's see, dangerous persons, offense, who went armed with, all right, so here, later Massachusetts amended its surety laws to be even more specific, authorized the imposition of bonds from individuals who went armed with a dirk, dagger, sword, pistol, or other offensive and dangerous weapon. Guy, some of you listeners, readers, whatever, are giant. That one slipped right past me, but here, dangerous and unusual. Let's see. Uh, so here, now they're quoting whether classified as an affray law or a distinct prohibition. The going armed law is prohibited. Quote, going riding or going armed with dangerous or unusual weapons. To terrify the good people of the land. That is quoting a prior law. That is not this decision. That is simply quoting the prior law. All right, Palazzi, you're ahead of me. You're reading the dissent or Sotomayor. Where's this? Where am I? Kavanaugh. All right, so dangerous appears 3,803 pages. Let me get down occurrence. Although Heller declined to undertake and exhausted, the Second Amendment attaches only supported by the historical tradition of prohibiting carry weapons and longstanding prohibition of possession of firearm by felons and mentally ill. Then in Bruin, this court refers to those three Second Amendment cases in opinion is in today's case. The court carefully builds on applies historical tests that those precedents have set forth, namely whether the new law is relevant. Examines. Sweetie, where are you going? New scooter about a week ago, and it's given her more mobility around the house. And she is now sneaking around. Let me see. For example, because the court that I'm in, let's see. Kavanaugh is, and unfortunately, Kavanaugh is writing to, in my opinion, to write. He's not really adding a lot. Barrett, all right, let me see where I'm at. We're knocking on an hour here, guys. Tell you what, I'm going to call it. I'm going to go through and read the concurring opinions. I'll get through Sotomayor. She might be reeling since she gave us that admission about common use semi-auto rifles, whatever. So let me get through this, guys. Narrow decision, not terrible for us. I think we come out with some takeaways. It's going to be interesting to see what Four Boxes and some other guys say. But I'm not going day drinking and crying in my bourbon or Jack Daniels. I think there's stuff for us to hang our hat on. It's going to have to be parsed. It's going to take several times to get through this to find all the nuances. I'll listen to um, Mark Smith. I'll listen to Bill Kirk over at Washington Gun Law. I'll kind of kibitz with some other guys and our attorneys and see what there is. But give me some time. I got a few other things out. We didn't take it in. I knew it was going to be a narrow opinion. If he wrote it, I thought Alito would have written a better opinion for us. But I think this is in keeping with the Chief Judge's tradition of not. I think he is trying to politely coax some of the lower courts, saying you're going way too far afield on stuff. And I think that them reiterating that modern weapons are protected, I think is a subtle shot at the Seventh Circuit, amongst a couple others. So, as always, guys, like, copy, subscribe. It's been a good hour. Maybe we'll do another live broadcast this weekend, depending. So we get. I'll have something out later today, maybe. I got to take the wife to physical therapy and run some more errands for her get together this weekend. But thanks again. It's not a bad day. It's not a bad day. So, as always, frag out.